Breaking news. The Supreme Court has just issued an emergency decision that could permanently end firearm permit systems nationwide, and the shockwaves are already spreading across every level of government, every courthouse, and every state in America. This is not a scheduled ruling that legal analysts had been anticipating for months. This is not a carefully orchestrated decision released during the court's normal term with advance warning and prepared commentary from all sides. This is emergency action from the nation's highest court, issued with immediate binding authority, targeting the very foundation of how states have controlled access to firearms for generations. The emphasis on emergency matters because it tells you this couldn't wait. The Supreme Court doesn't bypass its normal deliberative process lightly. When the justices act in emergency mode, it's because they believe constitutional rights are being violated right now, that irreparable harm is occurring, and that waiting for the standard appellate timeline would allow those violations to continue unchecked. This is unexpected and historic. Even gun rights advocates who have been pushing aggressively for expanded Second Amendment protections didn't necessarily anticipate that the Supreme Court would move this fast or this decisively on the issue of permit systems. This decision affects every state and every gun owner because firearm permit systems exist in various forms across the country, from shall-issue states with relatively straightforward processes to may-issue states with discretionary approval, from permit-to-carry requirements to permit-to-purchase mandates. If the Supreme Court has just struck at the constitutional foundation of those systems, then millions of Americans who thought they understood the rules governing gun ownership and carrying just discovered that the landscape has fundamentally changed. And almost no one saw this coming with this timing, this scope, or this immediate force. So, what exactly did the Supreme Court just do? And why does this emergency decision carry such extraordinary legal weight? The ruling is immediately binding on every court and every government official in the United States. When the Supreme Court issues an emergency decision, particularly one that grants relief to parties challenging government action, that decision takes effect instantly. There's no implementation period, no transition timeline, no opportunity for states to gradually adjust. The constitutional standard has been established and compliance is required now. Emergency decisions override lower courts instantly, which means that if federal district courts or courts of appeals had issued rulings upholding permit systems, those rulings are now effectively nullified by the Supreme Court's intervention. Lower court judges must apply the Supreme Court's constitutional interpretation regardless of what they previously held or what they personally believe about gun policy. Permit systems were directly challenged or frozen through this emergency decision. The court either ruled that certain categories of permit requirements are unconstitutional, or it issued an injunction preventing states from enforcing permit systems while constitutional challenges proceed, or it established standards so rigorous that existing permit schemes cannot possibly meet them. Regardless of the specific mechanism, the practical effect is that permit systems as they've traditionally operated are now in serious constitutional jeopardy. This forces states to respond right now, not later. State attorneys, general, governors, law enforcement agencies, and licensing authorities must immediately figure out what this Supreme Court decision means for their operations, what enforcement actions they must halt, what procedures they must change, and what legal exposure they face if they continue operating under the old framework that the Supreme Court has just called into question. Now, let's dig into why firearm permit systems specifically are now in constitutional danger and what the Supreme Court's reasoning means for gun regulation going forward. Permits are being treated as unconstitutional barriers to the exercise of a fundamental right. The Supreme Court's Second Amendment jurisprudence, particularly since the Bruin decision, has emphasized that requiring government permission before exercising a constitutional right is presumptively unconstitutional, unless that requirement has deep roots in American history and tradition. The court is focusing on historical tradition as the touchstone for evaluating modern gun regulations, asking whether a contemporary law aligns with regulations that existed during the founding era or during the period when the 14th Amendment was ratified. When that test is applied honestly to permit systems, those systems struggle to survive because permits as we know them are modern inventions lacking clear founding-era roots. There were no widespread permit-to-carry systems in early America, no government bureaucracies that citizens had to petition before exercising their right to keep and bear arms, and no discretionary approval processes where officials could deny Second Amendment rights based on subjective judgments. The Supreme Court's decision threatens multiple categories of permit systems. Permit to carry requirements that mandate government approval before carrying a firearm in public are vulnerable because they condition a constitutional right on obtaining prior permission. Permit to purchase mandates that require citizens to get a license before buying a firearm face similar constitutional problems. And discretionary approval systems, where government officials have subjective authority to grant or deny permits based on their assessment of an applicant's need or character, are the most constitutionally suspect of all because they give government essentially unlimited power to deny rights without objective standards or meaningful judicial review. The immediate consequence of this Supreme Court emergency decision is that states are now on the clock and facing enormous pressure to adjust their laws and enforcement practices. States must pause enforcement of permit requirements or face federal lawsuits that they're now very likely to lose. Gun owners whose permit applications were denied, who were prosecuted for carrying without permits, or who were subjected to lengthy delays and bureaucratic obstacles can now file civil rights lawsuits arguing that their constitutional rights were violated. And with this fresh Supreme Court decision on their side, those lawsuits stand a much better chance of succeeding, potentially resulting in damage awards, attorneys' fees, and injunctions that force states to change their systems. The conflict between state governments and federal constitutional authority is intensifying. Some states have built their entire gun control frameworks around permit systems, using those systems to limit who can carry firearms, to impose waiting periods and background checks, to create bureaucratic friction that discourages gun ownership, and to maintain discretionary control over Second Amendment rights. Those states view this Supreme Court decision as federal overreach, as the court imposing a particular interpretation of the Second Amendment that conflicts with how those states have regulated guns for decades. But the constitutional reality is that when the Supreme Court interprets the Constitution, that interpretation is binding on states whether they agree with it or not. Defiant states risk losing in federal court if they continue enforcing permit systems that conflict with the Supreme Court's constitutional standards. Federal judges will apply the Supreme Court's reasoning, plaintiffs will cite this emergency decision in their challenges, and states that resist will face mounting legal defeats, growing financial exposure, and ultimately the erosion of their regulatory authority. This is a direct warning from the Supreme Court that permit systems must be justified by historical tradition, not by contemporary policy preferences, and that states which continue treating the Second Amendment as a second-class right subject to extensive government gatekeeping will face judicial intervention. The legal chain reaction triggered by this Supreme Court emergency decision is already beginning and will accelerate rapidly in the coming days and weeks. Lower courts must now realign their jurisprudence instantly to conform with what the Supreme Court has just said. Judges who are hearing Second Amendment cases involving permit challenges must reconsider their analysis in light of this new decision. Cases that were headed toward rulings upholding permit systems must be reconsidered, and judicial reasoning that deferred to state regulatory judgments must be replaced with rigorous constitutional scrutiny rooted in historical tradition. Emergency filings, injunctions, and case reopenings are happening right now. Defense attorneys in criminal cases are filing motions arguing that their clients' convictions for carrying without permits are based on unconstitutional laws. Plaintiffs in civil cases are seeking emergency injunctions to prevent states from enforcing permit requirements. And cases that had been dismissed or decided against gun rights challengers are being reopened or appealed in light of this Supreme Court decision. Agency confusion and policy freezes are spreading across government at every level. State licensing agencies don't know whether to continue processing permit applications under the old rules or to suspend operations pending clarification. Law enforcement officers are unsure whether to arrest people for carrying without permits when those permit requirements may now be unconstitutional. And prosecutors are hesitant to file charges under statutes that the Supreme Court may have just invalidated. This is a domino effect that won't stop quickly. Each court decision applying the Supreme Court's emergency ruling will create precedent that affects other cases. Each state that adjusts its permit system will influence how other states respond. And each legal challenge that succeeds will embolden more challenges, creating a cascade of litigation that could ultimately dismantle permit systems across most or all of the country. So what does this Supreme Court emergency decision mean for gun owners right now, in practical terms, as this legal transformation unfolds? The approach should be awareness over panic. This decision likely strengthens Second Amendment protections and creates stronger legal grounds for challenging permit requirements, but it doesn't mean that all gun regulations have vanished or that gun owners can ignore every law. The legal landscape is shifting, and understanding how that shift affects your specific situation requires paying attention to developments in your state and consulting reliable legal sources. Old assumptions about permit requirements may no longer apply. If you previously believed you needed a government-issued permit to carry a firearm, or that you had to go through a lengthy approval process before purchasing a gun, or that government officials had discretion to deny your permit application based on subjective criteria, those assumptions may now be constitutionally questionable. The Supreme Court's decision suggests that at least some categories of permit requirements cannot survive constitutional scrutiny, which means the rules you've been following may have just changed. Gun owners should monitor state announcements closely because how your state responds to this Supreme Court decision will directly affect your rights and your legal situation. Some states will immediately suspend enforcement of permit requirements and adjust their laws to comply with the court's constitutional interpretation. Other states will resist, continuing to enforce their permit systems while preparing legal arguments to defend them. And still others will be caught in confusion, unsure how to proceed, and creating legal uncertainty for everyone. The emphasis should be on lawful, informed exercise of Second Amendment rights. The Supreme Court is protecting constitutional rights, but those rights exist within a framework of legitimate regulations that have historical grounding. Responsible gun owners stay informed about what the law actually requires, comply with valid regulations, and challenge unconstitutional restrictions through proper legal channels. So, what comes next? And why should this emergency decision be understood as only the beginning of a much larger constitutional transformation? Emergency rulings from the Supreme Court often signal that larger, more comprehensive decisions are coming. When the court acts in emergency mode, it's frequently because the justices are concerned about immediate constitutional violations, but it's also often a preview of how the court will rule when full merits cases on the same issues reach them through the normal appellate process. This is the opening move in a nationwide reset of how Second Amendment rights are understood, protected, and regulated. Permit systems that have existed for decades are now constitutionally vulnerable. States that built extensive gun control frameworks around those systems must now rethink their entire approach. And the legal battles over what kinds of gun regulations can survive the Supreme Court's historical tradition test are just beginning. More challenges to gun laws are inevitable. This Supreme Court decision will embolden gun rights organizations to file lawsuits attacking not just permit requirements, but also waiting periods, purchase limits, magazine capacity restrictions, assault weapon bans, sensitive place prohibitions, and every other category of gun control that might not have clear historical roots. Some of those challenges will succeed, some will fail, but all of them will reshape the constitutional landscape governing firearms in America. The Second Amendment framework just changed in a fundamental way, and the next moves could be even bigger. We could see the Supreme Court issue a comprehensive ruling that establishes detailed standards for evaluating all gun regulations. We could see entire categories of state gun control laws struck down as inconsistent with historical tradition. We could see a constitutional reckoning where decades of accumulated gun regulations are subjected to scrutiny they've never faced before and fail to survive it. The vigilance message for gun owners, state officials, and anyone who cares about constitutional rights is clear. Pay attention, stay informed, and understand that the rules governing firearms in America are being rewritten right now through Supreme Court decisions that carry the force of constitutional law. What just happened isn't the end of this fight. It's the beginning of a new phase where Second Amendment rights are taken seriously, where government regulatory authority faces real limits, and where the balance between liberty and control shifts in ways that will affect American life for generations.